Okay. So tonight we've got Sonia Tecker. Thank you for having a name up there. Sonia recently got married and I'm still adjusting to the change. Sonia is our legal services manager. She supervises a bunch of our different legal programs that provide legal representation at different levels to Tubman clients. And I'm going to let her tell you a little bit more of that. And then she's going to give you a quick summary of all of our legal programs.
Oops, sorry, I was doing too many things at one time. Let me switch this here. There we go. Okay. Hi, good evening, everyone. Like Michelle said, my name's Sonia Tecker. It is a little confusing because my email still says boss. So either one is fine. But I am the legal services manager here at Tubman. I've been here for about 2.5 years now. Loving every second of it. I'm a social worker by trade. And here I have the privilege of kind of being the program manager of a lot of our attorney services. And prior to my role here, I was involved in the legal advocacy realm for about 7 years. So I've really been in this kind of domestic violence legal realm. I'll be coming up on 10 years this year, actually. So this is something I'm super passionate about, and I'm really excited to tell you a little bit about it. Let me know whatever questions that you can possibly have in the midst of this presentation. We're going to keep it kind of short and sweet tonight. So feel free to pop questions in the chat or even come off mute. That's totally fine with me as well. We'll have some polls and whatnot as well. And with that, I think I will get started. Alrighty. So this is kind of our agenda for the night. So like I said, I'm going to tell you a bit about our legal team, give you kind of an overview of our services. We are going to spend a little bit of time talking about the difference between advocacy services and attorney services. And those are kind of the two main areas of focus for our legal team here at Tubman. So it's an important distinction to make there. And then we'll talk more about what that entails. So we'll talk about our legal advocacy services and then also our attorney services. And then at the end, I'll tell you a little bit about some other legal services that we provide as well. So who are we? The legal team here at Tubman is made up of a lot of different people. So we have legal advocates, we have legal services coordinators. That would be the team that I fall under and have the privilege of supervising. We have staff attorneys. We also have contract attorneys, and then also a very large network of volunteer attorneys. And then we have amazing interns and volunteers, always have. We, on the legal team, sometimes have just as many interns and volunteers as we have staff, which we feel so grateful for because they really kind of help this work go around and give us the ability to provide as many services as we're able to. So we have a lot of interns, but we do also have some volunteers that have been with us for a long time as well. So that's really amazing. All right. An overview of the different teams and kind of services that we provide. So in the advocacy services branch of the legal team, we have 3 service counties that we focus on, and each of them provide both civil and criminal advocacy, and we'll talk a little bit about what that means. But there are slight nuances to each county. So Hennepin, Ramsey, and Washington counties are the main kind of legal advocacy teams that we have. Like I mentioned, we provide civil advocacy in all 3. And then we do some version of criminal advocacy in each, but it is a little bit different in each county. Some counties, focus specifically on specific cities that we have contracts to be able to do that work with. Some counties, we provide advocacy for the entire county. Some do felonies, some do misdemeanors. There's some slight nuances between them there. But for the most part, they're all providing advocacy in the legal world. And then on the attorney services side of things, we have 2 main programs, or you can think of it too as we have kind of 2 main venues or areas of the law that we practice. and that's going to be family law and then protection orders. So Safety Project is the name of our program that deals with protection orders. So if you hear me talking about Safety Project, it's always going to be talking about orders for protection and harassment restraining orders. And then family law encompasses a wide range of different family law legal issues. And we have different kinds of services that we provide in both of those programs, ranging from clinics and like e-filing even is a service. We have brief services clinics, and then we do representation on both of those legal matters as well. All right, so just to kind of talk a little bit about the difference between advocacy and attorney services, and sorry to those of you who were in my breakout last week because we already touched on this a little bit. It is important and can often be super confusing. So I actually just drafted this kind of distinction for our website. So if you ever need to go back to kind of the difference, this is right on our website. You can always refer back to it. So legal advocates are knowledgeable legal service providers that can assist in navigating through the legal system. And while they don't offer legal advice or representation, they do provide a wealth of information and guidance on just general legal processes. And they can act as a bridge between the client and the legal system, and they're there as a support system. On the flip side of that, attorneys can provide representation and offer legal advice for a client's specific situation. So just to kind of elaborate on that a little bit further, legal advocates are a wealth of knowledge. By no means should we ever dismiss how much they know about these legal processes. In fact, because of the way some of our services are set up utilizing our volunteer attorneys, sometimes our legal advocates are really the subject matter experts on what it looks like to go through an order for protection process, because they're doing it day in and day out. They're constantly in that venue and drafting those forms and all of that. So they have a wealth of knowledge. They've seen a lot of these cases play out. They also do a wonderful job of safety planning with clients as they're kind of navigating through the legal system, both, you know, safety planning broadly, but also safety planning within the confines of, you know, however the legal system has gotten involved. So whether that look like, you know, in a criminal case, talking about different potential outcomes or treatments or whatever, or, you know, what to include in an order for protection, for example. Advocates have not only a wealth of knowledge on the legal system, but they also have a lot of knowledge on the dynamics of domestic violence and how those two things interplay. The big difference is that they cannot actually say, this is what you should do and provide that legal advice. Whereas an attorney can actually apply the specific facts of a person's circumstances to the law and vice versa, and then provide advice on how they should proceed. What is their best move in the legal system, essentially. And then the other big difference is in representation. Attorneys can represent clients. They can speak on their behalf in court with opposing counsel, what have you. And advocates are really there to come alongside of the client and support them through. Sometimes they, you know, will speak with the client, but they can't speak on behalf of the client. So there's a few interesting kind of nuances there. But that's really kind of what it boils down to. Advocates, like I said, you know, shouldn't be disregarded for their knowledge. They oftentimes can help just as much as an attorney about, you know, which path they should take. What they do is they really arm the victim survivors that they're working with a lot of information and support so that the victim survivor can make the best, most informed decision for themselves and have that support alongside versus just saying legal advice on, you know, what a specific person should do. Anyone have questions on this distinction? It can be a little bit tricky. All right, if you think of any, just pop them in the chat. And Joni and Michelle, if you guys can keep an eye out too, if I miss something in the chat, let me know. Mm-hmm. Okay, so let's talk a little bit more about advocacy services then, kind of keeping in mind that difference. Other thing too, I do like to mention on this note is it can be a little bit confusing also because attorneys also call themselves advocates, as they should. They are often advocating on behalf of the client. And actually, in a lot of languages, attorney and advocate are synonymous. It's like just one word. So that can be a little bit confusing. You will hear sometimes attorneys refer to themselves as advocates. And so that's why it is kind of important to know the difference between like our Tubman legal advocates and what they do versus our attorneys. Okay. So a couple questions, if you guys can pop them in the chat, I'd be really curious to hear what you think. What does person-centered advocacy mean to you? Just in a word or a sentence, what comes to mind? Focusing on strengths. Focusing on what outcome the client wants rather than what you think is best for them. Customized for the client. Pertaining to details of an individual. I'm seeing some of my folks from the breakout last week applying some of what we've already talked about. That's awesome. Yeah, you guys are all exactly right. It's focused on the client's needs and priorities and wants rather than ourselves, our own biases, the society's viewpoint on things, yeah, just preconceived notions, all of that. And one more question. Can you think of a situation where it might be difficult to agree victim survivors' choices as it relates to the legal system? Report or not to report? Yeah, both sides of that can be hard to understand or to agree with. A victim who doesn't want to leave or seek charges against someone who has hurt them or their children, yeah. Doesn't want to file an order for protection, choose to stay in an abusive relationship. Yeah, these are all great examples, and examples that come up on a daily basis, honestly, for our legal team. So great job. Keep popping them in the chat. I'm going to move on, but keep going. Okay, so kind of keeping this in mind then as we move forward, as much as we can kind of keep that framework that we really do want to provide person-centered, client-focused advocacy more than anything. And then sometimes exercising that within like the narrow confines of the legal system can be a challenge. So it'll let me move on. There we go. So I mentioned that we kind of have two main areas of focus in our legal advocacy teams, which is both civil and criminal advocacy. So to talk a little bit more about what criminal advocacy means, kind of just what it sounds like. These are advocates that are providing advocacy within the criminal realm. So they are providing support to clients who are victim survivors in crimes that are related to domestic violence. There are other agencies that do provide services for perpetrators of domestic violence related crimes. Here at Tubman, we're strictly for victim survivors. It's the only service that we offer in the criminal space. So as kind of I mentioned when I was talking about what advocacy means, advocates can act as a bridge between the victim survivor and the criminal court process and the different systems players that are within that process. So that could include law enforcement, police officers, prosecutors, probation, judges, correctional officers, you name it. There's a whole bunch of different people that are kind of players in the legal system, in the criminal legal system. And having an advocate kind of sometimes act as a bridge, help with that accessibility, help with understanding what's going on, help to be a voice as well, makes all the difference in the world for a victim survivor who's kind of going through that otherwise alone. So like I said, advocates are often giving a voice or really raising a voice as well for the victim survivors on the different things that are going on within the criminal case. So I listed a few here, but this is certainly not an exhaustive list. But things that we see happen in just about every court case, criminal case, is varying types of no contact orders will likely be discussed. There's a couple different kinds that come about as a result of a criminal case. And then there's also the orders for protection and the harassment restraining orders, which are civil orders, actually. So that can be a little confusing as well for clients to navigate. So the advocates will kind of help them figure out what those things look like. What does that mean? You know, how is it enforced? All of that kind of stuff. They'll talk through the different case outcomes as well. So kind of in the life of a criminal case, what's happening is a prosecutor and a public defender or defense counsel, or sometimes the defendant, are kind of negotiating back and forth to see if they can reach some type of plea agreement as opposed to going to trial. And roughly like 90% of cases do resolve in a plea agreement. So trials are actually fairly rare, especially with misdemeanors. And so most of the time, there's going to be plea agreements that are on the table, and victim survivors have a right to know what those potential plea agreements are and to give input on how they feel about those things. In criminal cases, sometimes people can be ordered to go through different programming or evaluation, such as like a mental health evaluation and recommended treatment, or chemical health, sometimes domestic violence, anger management, different things like that. And victim survivors have a right to provide input on what they would like to see when it comes to programming. And then they also help draft, write, sometimes speak victim impact statements as well. So victim impact statement is something that every victim survivor has a right to do and submit. And that usually happens at sentencing. So after a plea agreement has been reached, or if it did go to trial, after there's a verdict. And it's basically a chance for the victim survivor to talk about how this specific crime or this abuse has impacted them, and sometimes to share further input on what they would hope the sentence would look like to the judge. And victim survivors have a chance to read that aloud in court if they want, or they can just submit it as well, so that it's not read aloud. But advocates do a lot to kind of help a client process if that's something that they want to do, maybe what to include. You know, they might help them practice reading it aloud, different things like that, sometimes even read it on behalf of the client. So they play a big role in that as well. Okay. First poll. So true or false, Michelle's going to put a poll up here if you can all submit your answers. In Minnesota, victims of domestic violence have the option to press charges against their perpetrator.
Okay, we've got about 2/3 of people responding so far. We've got just a couple more left. Okay, I'm going to end it and show you what everybody
Right.
thought. Can you see this?
I can see it, but I could just see it the whole time. I don't know if everyone else can.
Okay.
So it looks like you all answered true. Actually, it's false. So in Minnesota, victims of domestic violence actually don't have the power to choose whether or not their perpetrator is charged. That's actually something that is completely up to the prosecutor. Sometimes, hopefully, victim survivors have the option to provide input and you know, have some say, or at least be heard on how they feel about the matter. But the truth of the matter is, even if that happens, ultimately it is the prosecutor's choice to decide whether or not to charge someone with domestic violence. And unfortunately, the real truth of the matter is sometimes victim survivors aren't even being asked before that charging decision is made, which is in large part where legal advocates come into play as well. This does vary a bit from state to state as well, I should mention. So it is a little bit different. And that is specific to domestic violence as well. So if it's a non-domestic assault, you know, if you get punched in a bar by a stranger, you do have that option, whether or not to press charges. In Minnesota, in domestic violence cases, that falls completely on the prosecutor. Does anybody have questions on that? Ready. Like I said, feel free to pop them in the chat if you think of them.
Yeah, so just like
Yeah.
so I'm not like a legal at all. So the prosecutor it's up to the prosecutor, not the victim.
Correct.
So just like walk me through that. Like if it's me, it's my lawyer or it's the other person's lawyer. That might sound dumb, but I just don't know.
No, that's a wonderful question, and I think can be a kind of a sticking point. So kind of the unique part of the criminal legal system is that it's usually like it'll say the state of Minnesota versus the defendant's name, right? And so that's kind of the unique part of the criminal legal system versus like most other legal venues, is that it's not one party against one party. It's the state or the government against the defendant. And so a prosecutor's job technically is to represent the state and like overall public safety. And so ultimately, basically what happens is like an incident will happen, you know, police report, whatever, maybe there's an arrest, maybe there's not. And usually in those beginning stages, a prosecutor will receive the criminal complaint, the police report, you know, just the immediate stuff available. And they'll make that decision about if they want to formally charge someone or if they don't want to. And to be honest, usually that is a decision that's based on if they think they have a winnable case. So it has less to do, and that's not across the board, but it tends to have less to do with, you know, what the victim survivor is wanting. Although, like I said, sometimes you will have prosecutors that really seek out that information and take that into account. It really just depends on the prosecutor. Does that help? Awesome.
So you got a couple questions in the chat.
I see that. Whoever represent victims of DV who are facing charges, criminal or civil, that are a result of DV. We don't here at Tubman. That being said, we do fairly often have clients come to us that maybe have a history of domestic violence and are maybe now the victim survivor in a specific scenario. And that's not a deal breaker for us. We know that violence often does go both ways. There are a lot of different dynamics in these types of intimate partner relationships. And so that's not necessarily a deal breaker for us to work with that victim. That being said, we don't represent or provide advocacy services as someone is the defendant moving through that process. If that makes sense. And then I see, is the decision a potential barrier to coming forward? Is this well known? Just women advocates explain this before the survivor makes a claim. Oh, great questions. Love these. It absolutely is a barrier to coming forward. We know that these specific crimes are super underreported. Domestic violence for sure, and even more so sexual violence for the same reason, along with many others. Going through the legal system is incredibly grueling and often re-traumatizing in general, of just even past reporting, even if it does get charged. So there's a lot of different reasons and things to consider when victim survivors are considering coming forward with something that's happened to them or that they're experiencing. Hopefully, if a Tubman advocate has the ability to talk with a victim survivor prior to, they would be having those conversations, absolutely. That's, you know, these are the daily safety planning conversations that we're having. And oftentimes that safety planning does look like, is it a safe and good move for you to report to police? Oftentimes our criminal advocates are actually learning about the crime because they actually received a copy of the police report. And so in that situation, then they're kind of playing catch up a little bit after something's already occurred. If they have the opportunity to tell them, as early on as we can, we're giving as much information to the victim survivor as we can so that they can make the best, most informed decisions for themselves moving forward. Those are all great questions.
Sonia, just to clarify, so pressing charges is not in the victim survivor's control. But like if they want to get an order for protection or something, that's a totally separate thing. It's not related to this piece of the picture.
Yes, exactly. So this is specifically as it relates to someone being charged with a crime. And like I did mention that, there are no contact orders that can come about as a part of a criminal case, but there are also no contact orders that a victim survivor can petition for themselves. And there doesn't have to ever have even been a police report or anything like that. It's completely separate, which you gave me the perfect segue into my next slide here, which is to talk about civil legal advocacy and protection orders. So this is something that a victim survivor would choose to file for themselves. Again, you don't need proof. You don't need a police report. You don't need any of that. You just kind of file it with your story and the allegations that you're making. And so legal advocates provide a lot of support on behalf of clients who are seeking a protection order. And these protection orders, I'm not going to get too far into the weeds of like what qualifies you and whatnot, but really what it comes down to is protection orders, orders for protection specifically, is something that you can file against a romantic or household member. And there's more specific definitions of that, but that's kind of what it comes down to. And there are certain kind of allegations or behaviors that would kind of have you be eligible for an order for protection. The other type of protection order you can file is a harassment restraining order. And OFPs tend to be largely focused on physical abuse, which we obviously know is not the only form of domestic violence that our clients are experiencing. So that can be a challenge sometimes, but harassment restraining orders are another option as well that have a much broader definition and different things that could be taking place that help you qualify for a restraining order. So how do legal advocates help? They help draft the petitions in the first place. They can navigate as the order kind of moves through the court process. Service of these orders, getting the other party served with the order so that they know that this exists, can sometimes be like the biggest hurdle to jump through on these matters. And they do a ton of work to make sure that service is occurring in a timely manner, all of that. They do attend court with clients, and they obviously do quite a bit of safety planning every step of the way through, including enforcement once hopefully an order has been ordered. They also refer to the Safety Project, which I'm going to talk about in a minute, which provides attorney services on these matters, so legal advice and representation. And then they partner with the attorneys on the case as well. So I'll talk about this a little bit when we get to Safety Project stuff, but I think what I take so much pride in the Safety Project is that it is really built on the partnership of attorneys and advocates. And as I was talking about the differences earlier, those are really kind of the reasons we believe that the combo is really the best team that a victim survivor can have as they're moving through this process. If they can have both an advocate and an attorney, they're equally important. They serve different roles and have both such valuable skills that they can bring to the table. And so when we can get, the victim survivor, the attorney, and the advocate all working together, we found a lot of success in that. And it's really unique to our program here that we're trying to get to catch on elsewhere as well. So that's a bit about protection orders. Anyone have questions on that? I'm going to pop it to the next poll. You can feel free to throw questions in the chat as well. Okay, so in Minnesota, an order for protection shows up on someone's criminal record, true or false? This one's a little more split.
Okay. Yeah. Couple more people out there. Pick a button. Okay, I'm gonna end it. So you can all see what happened.
It's pretty well split, almost 50-50.
It's very interesting.
Yeah, super interesting. The answer is false. So in order for this kind of a trick question, to be fair. So in order for protection in Minnesota does not automatically show up on someone's criminal record. It's a civil order that the client files. You know, like we said, it's kind of fully separate from the criminal legal system. That being said, the way orders for protection are enforced is through the criminal legal system. And so someone can be arrested and charged with violating an order for protection. So the order itself won't automatically show up on someone's criminal history. But if they violated and were convicted of that violation, that would show up. That in and of itself is a crime. So this is a question we get quite a bit from our clients is, you know, because they're worried, I'm going to file this order for protection. Is this going to show up on, you know, this person's criminal history? Are they going to get kicked out of their housing? You know, is this going to be an issue with employment? You know, all these different things. I have kids with this person, all of that. And so that's the answer, is that it's really only going to show up on their criminal history if they are to violate it and then get convicted. Any questions so far? Alrighty, and I will keep going.
I have a question.
Yeah,
Excuse me, Sonia.
hit me.
Is there an easy answer to this? Because I know you can really get deep, but what are the best avenues for, you know, we've got a mental health intern in the room, we've got resource advocates, shelter youth workers. What's the best avenue for how to, like, if somebody's like, yikes, you need a legal advocate, or some of these services that you've talked about so far?
Yeah,
Is
there is an easy answer to that. And some of you will be in this room tonight. Our RAs are actually usually our first point of contact for our advocacy referrals. So aside from, we do have.
So RA is resource advocate.
Yes, sorry,
Perfect.
thank you. Yeah. So like I mentioned with the criminal stuff, we have some contracts with cities where they contact us immediately after an incident and send us a police report so we can do some, you know, really quick advocacy and kind of crisis work on that front. But the rest of our advocacy referrals, people that are seeking an order for protection or maybe, you know, need help kind of in the midst of a criminal case, that resource line is kind of the best one-stop shop for all of our legal services, including the attorney services that I'm about to get into. So that's kind of the go-to line. Thanks, Jenny. All righty. So we're going to switch gears a little bit and chat about our attorney services. So again, just to make that distinction, our advocacy services are not legal advice or representation, but everything else under the sun. Our attorney services are legal services where we're providing legal advice on client-specific scenarios and representation as well. So I'm going to talk first about the Safety Project, which I've already mentioned a few times, but our Safety Project program provides legal services on protection order cases. This actually, I should just preface this with all of our attorney services. We are kind of a mini legal aid program within Tubman. And so we are serving low income clients. We do have financial eligibility requirements. We don't set those are set by our funders. So just so you know, we try to make as many kind of creative moves as we can to serve as many people as possible, but we do have eligibility requirements. We are primarily serving folks in Hennepin, Washington, and Ramsey counties on protection orders. And we provide pro bono representation, which pro bono is just a fancy word for free. And then 30-minute clinics where folks can get free legal advice on what to expect on their upcoming hearing, you know, different advice on how they should proceed, that kind of thing. And then we also do e-filing services for our Tubman advocacy clients. So as I mentioned, the Tubman advocates are doing a ton of work drafting the orders. And these are, you know, fairly hefty orders, and we do a lot of them as well. And so the ability to e-file them is so incredibly helpful and makes this a much more accessible service. And so we partner with our advocacy teams to e-file those cases on behalf of the clients. We do partner both with our own internal advocates here, as I've mentioned, and then we also, with the Safety Project, have specialized partnerships with all of the advocacy agencies in the 3-county area. So anyone that is providing other advocacy services, and there's quite a few, particularly in Hennepin County, there are a lot of different advocacy agencies. We have partnerships where they are able to refer directly with us. We do like a release of information, and then they can work together with ideally an attorney who takes the case moving forward. I meant to mention this earlier, but you know, I mentioned a little bit about how advocates help clients kind of navigate through the legal system, and protection orders and like service can be really challenging, things like that. The order for protection process was originally designed to be something that clients could just access pro se or unrepresented. And over time, it's gotten just more and more complicated and complex and hard to understand, particularly for someone who is in the midst of experiencing trauma. And I would say we've even seen that rise even further since COVID. We've had the introduction of Zoom Court, which in a lot of ways has been really incredible. It's made the system more accessible for clients for sure. You know, not having to find transportation to get downtown, childcare, pay for parking, all of those different things, just time in general. And most importantly, not having to be in the same room as the person who has harmed them. So it's been really amazing. The unfortunate unintended consequence of that is that we have seen a lot more opposing parties, A, show up to these hearings, and B, show up with counsel represented by an attorney. And so having our clients, the victim survivors, have representation has really become an increased need since COVID times, because as you can imagine, things get really unbalanced when one side is represented and the other side is not. So this has become definitely increasingly important, and the demand has really shot up. So that is something that we're really focusing on in the Safety Project. So our attorneys assist clients with managing just expectations for what's going to happen in court, preparing evidence and testimony. They do represent the clients in court, and they negotiate settlements with opposing counsel. Sometimes there's no need to have like a trial where you provide testimony and all of that stuff if the parties can kind of reach an agreement. And so they're doing a lot of that work as well. Any questions on the Safety Project? What I really want to just always emphasize in this is that partnership, again, between advocates and attorneys is really kind of what makes the program special and really successful for clients. And we take all of our referrals in the Safety Project directly from advocates. So it is a little bit different in that way. In our family law program, clients can reach out and ask for help themselves. In the Safety Project, we're partnering specifically with advocates to provide that wraparound service.
When you say advocates, can you explain, like, because we've got advocates here that do different things. Do you mean
No, that's a great point. Specifically legal advocates, if someone were to and we do sometimes, especially from other agencies, have advocates who aren't like legal advocates refer to our program, which is okay. Ultimately, we are going to try and connect the victim survivor, as long as they want that, to a legal advocate that can provide ongoing advocacy through the kind of legal process in addition to an attorney, because we just really find that to be the most successful way. So typically we would always encourage you, if you're like an advocate who's maybe going to be working in the shelter or in one of our other programs, if you have a client who is going through the order for protection process, I would definitely recommend getting them first connected to advocacy, and then advocacy will also connect them to the safety project. Good little clarification. All right, next poll.
Sonia, hang on just a second. You've got one more question in the chat about what is a 30-minute clinic?
Oh, yes. The 30-minute clinic, so just going back, maybe not. There we go. The 30-minute clinics are just what they sound like, basically. It's a chance for a client to have 30 minutes to chat with an attorney over the phone and just ask all of their questions and get specialized legal advice on how to proceed, what they should do, what to expect, maybe prepare some testimony, talk through the different options, that kind of stuff. So it's not representation. That is important. Alrighty. Okay, next poll. In 2023, Safety Project worked on how many cases? Is there options there?
Okay. Kind of spread out.
Spread out, yeah. It looks like the prevailing answer was 267. The actual answer is 325. So that is the number of open cases that the Safety Project worked on in the year 2023. High number for sure. Alrighty. Carrying onto our family law program. So we serve, again, low-income folks, primarily in Hennepin, Washington, and Ramsey County. And this is on family law matters. We have a number of different levels of service, types of services within the family law program. Similar to the Safety Project, we do 30-minute clinics, and we also do representation. And then we do a lot more like one-off advice calls, which is kind of like a clinic, but it's less scheduled. And then we also have brief services clinics in family law, which are really cool. They're kind of like a workshop almost with an attorney, where you get to spend anywhere from like an hour to 2 hours with an attorney, oftentimes drafting actual paperwork, preparing actual evidence, whatever it might be, drafting, filing a motion, all that kind of stuff. So it's a bit more like hands-on, goal-oriented type of work than a 30-minute clinic is. And we provide a lot of brief services clinics in this program. So that's a really cool service. So in the family law program, attorneys, again, are assisting clients with kind of managing expectations for court, walking them through the entire process, kind of step by step, preparing evidence and testimony, representing the client in court, speaking on their behalf, speaking with opposing counsel, negotiating settlements, all of that kind of stuff. My next poll. Oops, I thought they were all going to pop up. Uh-oh, did it freeze for you guys? Oh, there it goes.
There we go.
Okay. All right, so Tubman works on the following family law matters. Which do you think? This was a hard one.
This is a hard question.
I know. I did that on purpose. And there's also not an exact right answer. So
Okay, I'm gonna end it and share.
All right. So most people thought divorce, custody, child support, and child protection. The right answer for this is A, divorce, custody, child support, and parenting time. Like I said, kind of a trick question. There's not an exact right answer because, like I said, we do have kind of the ability to be somewhat creative in which cases that we take and kind of how we can prioritize our resources. So there are exceptions to every rule. Well, let me take that back. There are not exceptions to every rule, but for some. So, for example, we have done grandparent visitation once or twice when there's been some really specific circumstances and like high level safety concerns, things like that. But for the most part, it's not one of our focus areas, like a divorce or a custody cases. I do want to specifically highlight the fact that we don't do child protection cases here, which I know it kind of feels like it doesn't make sense. And you would think that gets grouped in, particularly because we have such a focus on domestic violence. The specific reason for that is that child protection happens in a completely different court and venue than family law matters do. It takes place in juvenile court. And juvenile court has a whole separate bunch of rules. And they also have, similar to the criminal legal system, they have public defenders in place. So there's not a ton of civil legal aid programs that offer legal aid on child protection matters because there is the ability to have a public defender in that space as opposed to a family court. So those are kind of the two main reasons that we don't practice in juvenile court. And I have a couple different questions in here. Oh, it's about parenting time. Parenting time is also called visitation. So that's really just the schedule if there is some kind of joint custody. Or sometimes, I guess, if there's not even, sometimes one parent will have 100% physical or sole custody, but the other parent will just have parenting time or visitation to the child. So it's not custody, but it is still the right to see your child and spend time with them, those kinds of things. There can be different parameters around what parenting time looks like. Every custody case is going to involve parenting time, so that's kind of goes right along with custody. But that's kind of the nuance there is just a little bit difference between custody and parenting time. Does that answer that question? Anyone else have questions on this? Alrighty. Like I said, divorce and custody are our two main focus areas. It makes up, I don't know, 95% probably of cases that we take as divorce and custody cases. Child support is obviously wrapped right into that. Most divorce cases and custody cases also involve child support. We don't take a ton of child support cases that are strictly child support and don't also have a divorce or custody case going on, just simply because we don't have the resources for it. And there is child support cases are a little bit more formulaic. There's a calculator, things like that. And so we really do focus the majority of our family law services on divorce and custody. Would Tubman volunteers and interns be mandated reporters? This is a question for your supervisor. It does vary a little bit between the different programs. I will just specifically mention as it pertains to the legal team, we have both advocacy confidentiality, which is its own thing that applies to most of the agency. And then on the attorney side, we also have attorney-client privilege. So there are sometimes some kind of weird nuances around what kind of confidentiality we have, what we can share with who, all of that kind of stuff. But ask your specific supervisor how that applies to you specifically. And Joni, Michelle, if you want to add anything.
As a resource advocate, you definitely would. Pretty much everybody except our mandated reporters here at Tubman, where it gets less clear is with the legal folks.
Legal, yeah.
But the rest, it's pretty clear.
For sure.
please do check in with Siri about that, resource advocates.
Yes. Alrighty. Finally, just kind of to wrap up, a couple other legal services that we do offer here at Tubman and that we are often providing for our clients. We do something called a legal needs assessment. Really, we do this primarily for shelter clients. On some occasions, we've been able to do them for other clients that are receiving services from some of our other programs. So it's not necessarily only for shelter clients, but that's typically how we have it set up. A legal needs assessment is kind of an enhanced advice call or clinic. It's kind of like a legal triage for our clients where they'll get to have an advice call with an attorney and kind of just go through their different legal concerns. And it could be on multiple issues. And they can receive just like brief legal advice. And then a lot of resources and referrals as well. So maybe someone who is in our shelter has some legal questions about housing. They're looking for an order for protection or to get divorced. And they're also, have some concerns about immigration or need legal help in the immigration world. So then maybe our attorney would kind of talk them through those different things. They would safety plan around how to prioritize those legal issues as well, which ones to kind of attack first. Provide some kind of brief legal advice if they can, because they obviously don't step outside of their own expertise. So for example, on the immigration side, we would likely do a referral to our partner agency, Immigrant Law Center Minnesota. We do have a partnership with them. And so we would try and get them connected to the right resources, whether that be us and they're going to continue receiving, maybe family law services from us, but also outside of Tubman, maybe immigration or what have you. So that's what happens in a legal needs assessment. We do offer assistance with breaking a lease, which does not have to be done by members of the legal team. Actually, anyone who works for Tubman can provide this assistance to clients. Myself and a few of my colleagues have been bopping around to different programs, kind of doing little trainings on how to do this. It's actually, as far as legal processes go, a fairly simple process. Anyone who's experienced domestic violence in Minnesota has the right to get out of their lease. And there's a few different kind of steps and things and qualifications, but it should be fairly easy. In order for protection, we'll get you right there. You automatically qualify, or they might need a written statement from someone who works for a domestic violence provider, such as Tubman. And we have that template like already set to go. You just kind of got to fill it out and submit it to the landlord. So we do provide a lot of assistance on this front. If for some reason landlords decide to cause a stink, as they do sometimes on this issue, our attorneys will also step in and provide some more advocacy and representation on that front too. And then we also do assist in the Safe at Home address confidentiality program. Again, this is not legal team specific. We have Safe at Home advocates across the agency and most programs. This is a program, if you haven't heard of it, it's through the Attorney General's office. You take a training to get certified to be a Safe at Home advocate, and then you can help clients apply to this program. Which provides that their address would be confidential everywhere. There are some really specific kind of things to follow and ideas of like when you should apply for this program and things like that. And there's a fair amount to consider, but overall, this is a really great resource for a lot of our clients who need to protect their address. So this is something that we do on the legal team quite a bit as well. Alrighty, that is my dog Louise. Wondering if you have any other questions. Nothing.
Quiet group.
Quiet group. You guys asked some great questions, though. Thank you for that. Always love when I get questions. Well, thank you for listening. I hope you learned something. This was I know both a lot of information and not enough at the same time. So hopefully you kind of know where to go from here and an overview of the services that Tubman provides. And when you're working with clients and they could maybe benefit from speaking with someone on the legal team, you know where to send them.